Okay, good afternoon. Assalamualaikum warahmatullahi wabarakatuh. All right, class. Today we will continue and look into the appointment of additional director and alternate director. Okay, we're going to look into the requirements, we're going to look into the procedures, how to go about it. Okay, you should by now know, okay, the relevant sections available to the appointment of additional directors. That means maybe you want to add, okay, to your existing directorship, okay, or if let's say you have a constitution and your constitution says that minimum is one director, okay, and maximum director is, let's say you specifically mentions, okay, 4 directors. So now you have one director and you think that there is a necessity to have, okay, another one additional director, for example, then you can go for another new appointment. And of course, on top of that, maybe, okay, your existing director is kind of busy, okay, therefore your existing director is also allowed to have alternate director. But bear in mind, if you have alternate directors, okay, what is their responsibilities, whatever, it should be mentioned, okay, inside your so-called constitution, okay, right, inside your so-called constitution. Okay, let's move. Okay, let's move to what's next. Okay, so in the learning outcomes, okay, you will be able to identify the meaning of officers and also the meanings of company directors. Okay, and then to explain, okay, the requirements and procedures, okay, for appointment of alternate director, and then to describe the requirements for appointments of additional directors. Okay, right. First, let's look into your so-called, okay, sections 196. Okay, let's look into your so-called sections 196. Okay, right. We look into first, okay, regards to directors. Okay, with regards to the so-called directors. Okay, so sections 2, okay, section 2 of your so-called, okay, define directors to include, okay, any persons occupying the positions of director of a corporation by whatever name called, and include a person in accordance with whose directions or instructions the majority of directors of a corporation are accustomed to act, and an alternate or substitute director. So in your Companies Act itself, okay, in the section 2, okay, the interpretation is already concluded. Okay, when we talk about director, we also talk about alternate director, okay, or substitute director. Okay, right. For example, section 213, okay, mentions that where a director exercise his power according with Companies Act for purpose, okay, for a proper purpose and in good faith, exercise reasonable care, skill and diligence, with the knowledge, skill and experience reasonably expected, including his additional knowledge, skills and experience with which he in fact has. Okay, so this basically what some of the so-called scopes, okay, of a directors, right? So you also have what we call as alternate director. It is common for a director to appoint another person to act on his behalf in his absence. Okay, this is already explained also under the sections 2, right? Okay, so under the company's constitution, a director with the approval of the board appoint another to be alternate director or substitute director in his place during such period as it thought fit. Okay, so the appointment of alternate director does not increase the number of directors in your company. Okay, although he is still under the particular sections 2. Okay, so alternate director also is considered as director of the company, but it will not increase the number of directors that you have in the company. Okay, so that's you have to bear in mind. And the appointment of directors, alternate directors, yes, okay, it would be requested by the existing director, but it has to be approved by resolutions, okay, of the board of directors. Okay, so what is the functions of this alternate director? I think you should already know by now. Okay, right? Should know already by now. Okay, so if you want to appoint an alternate director, okay, if you only have one director, then you cannot have an alternate director. Okay, so minimum number of directors must follow these rules. Okay, ordinarily reside in Malaysia but having a principal place of residence in Malaysia cannot be alternate or substitute directors. Okay, so a de facto director cannot be considered to make up the minimum number of directors as required by the statute. That means you must have an existing director first, then only you can have alternate directors. That's basically the idea here. Okay. All right. So, of course, okay, when we talk about director's appointment, we are looking at the age and also whether or not the directors needs to have a director's shareholding. Okay, so a person must first give consent to the appointment as director. Okay, what sections that says that a person must be consent to the appointment as director? Okay, so you have to write down. Okay, in the activities, what sections will it need to comply before can be appointed as director? Okay, right. The constitutions may require a director to hold a specified amount of shares as per conditions being elected as director of the company. Okay, and then there's also got additional. I mean, that's the minimum, and then subsequent. Okay, subsequent appointment. Okay, can also be made, right, to fill in certain vacancy, maybe removal of directors, okay, resigning of directors, okay, or the directors pass away, or just because you want to have additional directors is also possible. Okay, so the board at any time appoint a directors, okay, but this power is subject to the constitution. So the constitution can provide additional conditions or limits the board authority to appoint new director based on casual vacancy and also circumstances. Okay, right. Okay, let's continue. When we talk about director's shareholdings, okay, we already know kalau it's mentioned dalam the constitution that every director being appointed must own shares of the company minimum what amount, then must comply lah. Okay. But if it's silent in the constitution, then that's it. You don't need to have it. And if you don't have constitution, then also it's no need to have a director's shareholdings. Okay. Right. Appointment of directors. Okay. You knew that okay, for the so-called okay, public company, you must have at least 2 directors. Okay, and not include alternate or substitute directors, okay, in determining the minimum number of directors. Okay, that will be for public company. Okay, for private company, okay, right, for private company, you knew that the minimum will be 1 directors at any one time. Okay, at any one time. Okay, so all directors must be natural person, must be 18 years old of age. Okay, and then the constitutions. Okay, if you have a constitution, then you can put in the constitutions. Okay, that a director's office is vacated if he becomes of unsound mind, for example. Okay, of course, sections 204 expressly state that the act of a director in any way will be valid, okay, notwithstanding any defects, okay, which may later be discovered in his appointment or his qualifications. Okay, so once appointed, okay, so whatever yang dia buat, okay, whatever agreement that he entered on behalf of the company is valid. Okay, otherwise, you stay after that, right? So, uh, you knew about the first appointment. Okay, the first appointment will be whatever that's mentioned in the section 14. Okay, section 14, subsection 3. So, any others appointment after that, you don't need to follow the section 14, subsection 3. Okay, right. So, if you have a subsequent appointment, what will be the documents needed to be applied here? What sections needed to be applied here? One, what section? Consent. Okay, director's consent is required. That means before a person, okay, can be appointed as a director of the company, you must get director's consent. That means sections 201 is applicable. Okay, second, there must be a resolution, okay, pertaining to the appointment of that particular directors. Okay, because let's look into your sections 202, okay, sections 202, which stated, okay, if you look into your sections 202, okay, a person or subsequent director, okay, 202.1 is talking about a person named as director in the applications for incorporation shall hold office as a director from the date of incorporation until that person ceases to hold office as director. Okay, 202 subsections 2, all subsequent directors of a company may be appointed by ordinary resolution. All subsequent directors of a company may be appointed by ordinary resolutions. So, under the particular sections 202 subsections 2, okay, right, as mentioned here, unless it's in the constitutions or due to casual vacancy, right? So appointment of new director, when we say ordinary resolutions, it means, okay, it needs to get approval from members of the company. Okay, it has to get approval from members of the company. So for this exercise, you have to assume that you do not, okay, you do not have, right, a constitution. Constitutions is not applicable to your company yet. Okay, therefore, the appointment of this additional director must be done using members' resolutions, ordinary resolutions. Okay, so for these ordinary resolutions to be passed, you're going to do it as members' circular resolution. Okay, you're going to prepare members' circular resolutions. Okay, that's on the so-called appointment of additional director. Okay. Okay, then we look into alternate directors, or in other words, we call it as what we call it as substitute director. Okay, so the constitutions of company often provide for the appointment of alternate or substitute directors. Okay, so alternate directors are persons to whom some temporary delegations of authority is made by the principal director, appointing the alternate directors to act in his absence in the board meetings. Board meeting. Okay. Right. The constitutions normally provides for the directors for the appointment of alternate directors. Usually states that a director may, with the approval of other directors, appoint alternate director for a period that he thinks suitable. Okay. So the appointment may be terminated at any time by notice in writing from the appointer, but until that happens, alternate director is entitled to notices of meetings and to attend and vote at the meetings and to exercise all the powers, okay, of the appointment in his place. Okay, so you don't have constitutions, then how? Yes, you can still appoint, okay, the alternate director. See? Yes, you can still appoint the alternate director, but then, okay, you just follow the sections 2.2. Okay, if you want to have more, then you're going to have uh, to need it expressed in the constitutions. Okay, so for the time being, one, assuming that there is no constitutions, therefore, the appointment of these alternate directors, okay, will be based on the so-called sections 2, subsection 1. Okay, and the appointment of the additional directors must be by ordinary resolutions. Therefore, here you're going to have, right, uh, two, you know, two different resolutions be prepared. One, okay, members' resolutions on the appointment of additional director. The other one, okay, board resolutions on the appointment of alternate director. Okay, what's important is the date that you're going to put on both appointment. Okay, so it will be up to you actually. Okay, you can have alternate director be appointed first. Then after that, subsequently after that, you have you appoint additional director using members resolution. Okay, right. So first you must receive, okay, a duly whether it's a additional director or alternate directors, the same thing must be done. Okay, the same thing must be done. Okay, right. So that means receive a duly signed and attested sections 201. Okay, and then received letter of consent for bankruptcy search. Okay, directors, if it's additional directors, okay, must be appointed by general meeting, okay, or circular resolution, sorry, okay, members resolution, right? And then directors must disclose interest in contracts, properties, and offices, okay, and launch your to CCM section 58, and then update, okay, the section 57, register of directors, managers, and secretaries, and assuming that there is no, okay, compliance to share qualifications requirements, then you don't need to have it. Okay, if you want to have a share qualifications requirements, then you need to comply with whatever that you have done in your workshop 1D. Okay, right. So this will give to you, okay, whether you want to say that, okay, there is a director's directors share qualifications, but in order to have directors share qualifications, means that you must have constitutions. Since you still do not decide yet to have a constitution, I will say for the number 7 is not compulsory. Okay, it's not compulsory. But number 1 until number 6, it is compulsory to be prepared when you want to appoint additional director. Okay, right. For this is organization. Okay, from 1 to number 6. Okay, so you must decide to appoint additional directors to your existing, okay, a better insight of your new business venture. On top of that, one of your directors give to the company letter to appoint his brother, okay, for example, as alternate director for him, together with his brother consent to be appointed as alternate director. Okay, so you need to prepare and do the necessary submissions, okay, of this particular workshop 2B assessment, right?